Okay, Mr. Dragan Dakic, hello. It's
Hello.
great to have you here. You are professor of international law at the faculty of the Law University of Wywiad,
Exactly.
and you are nowadays in Warsaw as one of our visiting professors at the Collegium Intermarium.
Yes, that's all correct. Thank you for having me here. It's my pleasure.
It's our pleasure as well. I wanted to talk with you about eugenic abortion because nowadays we are living in times where this phenomenon is becoming more and more widespread across Europe, not only, but let's stick with our continent. We have examples where eugenic abortion has become, I think the least we can say, normalized. We have the example of the Netherlands, Denmark, but also Iceland, which recently was communicating to the world quite proudly that this country, which has roughly 300,000 inhabitants, got rid of the Down syndrome. Obviously, this getting rid of the Down syndrome is not to be attributed to some healing or some cure. It's just based on eugenic abortions. In other words, the government is encouraging to get rid of a part of its own population based on certain characteristics, in that case, the genotype of the person. And I wanted to ask you, how would you relate to this in the framework of genocide? You are a specialist of the topic of genocide, of its various legal definitions. And I wanted to ask you double question. On the one hand, can we talk about a form of genocide in that case? And on the other hand, what would need to be fulfilled? Which conditions should be fulfilled to qualify, if I can say so?
Yeah, thank you for such a comprehensive introduction into the question. And actually, it's a highly debated issue. Eugenetic abortion is something which is highly debated due to some historical background of such practices, which are connected to Nazism and Nazi ideology, basically, which claimed right to be healthy and superior, etc., etc. So even though the Nazi era is ended, we do have some practices remain after it. Although the Nazis were not the one who invented that eugenic program, we are all aware of it, but still they were promoting it aggressively. So behind that scope of framework, of the frame discussion about eugenic abortion, well, to connect your question with eugenic abortions and genocide is not easy task. And what we can see on the example which you have mentioned, that of the Iceland, we can say, and to be sure, that we do have genocidal results at the scene. So maybe we cannot claim it or qualify that as a genocide at this particular moment, because there are various elements which needs to be fulfilled in order to reach that qualification. But we can see that effects which are similar to genocidal are actually taking place. So as you mentioned, it was a part of the population which was eliminated or exterminated from the general population. Basically, that's the idea of genocidal acts, to exterminate whole or in its part group as such. And first problem which we would have in qualifying that particular act as a genocidal is a protected group. So the dispute might arise if those kind of persons defined by genotype can be recognized as a group protected for the purpose of genocide under the Genocide Convention. So because its wording is strict and it enumerated only 4 groups which are eligible to be protected against genocide. So those are actually national, ethnical, racial groups, for instance. So if we would consider where could we subsume this group of people defined by their biological characteristics, maybe we could sort them within the ambit of racial group, since it's disputed in theory what race is. Is it decided by biological features of its members or something else? And we are actually at the point where we are saying that biological features are not decisive determinants of belonging to race. So we are actually accepting that race is sort of social construct. And in that sense, we can argue that people with Down syndrome could be treated as a race for the purpose of the protection against genocide. The reason to claim so perhaps is in the one characteristic of that group, and it's called stability. So its membership within that group is stable and it's permanent. That is the main feature of protected groups in general. So even though religious groups are protected against genocide, they are not that stable because it's possible to change religion. It's actually within the ambit of the freedom of religion to exercise religion or to change it or to not exercise it. So if that group is suitable to be protected for the purpose of genocide, even though it is not that stable, but in practice they are pretty stable groups, I think that we have strong reasons, legal reasons, to claim that persons with Down syndrome could be identified as victims of the crime of genocide, under the convention, of course. But still, there are many other elements which needs to be fulfilled in order to make such serious claim. I'm saying that such a serious claim because genocide is a crime of the crimes. So it's not, it shouldn't be that easily used in the, let's say, against different issues arising. So it is sort of exclusive criminal offense. It is so very sort of a special crime. And not many things can be qualified as genocide, even though they might appear so. So what we are having as the next issue is determination of genocidal intent. So we should have proof or evidence that the purpose of those policies which resulted in extermination of one group are actually motivated with genocidal intent. And this is the most difficult to prove. So when we are talking about genocidal intent, it is almost impossible to prove it under the present-day conditions because it would be almost unimaginable to see written statement or order to commit genocidal acts. However, international law is of course evolving, and we do have some additional evidentiary instruments which could be used in order to detect existence of genocidal intent. So it's not always necessary to have clear evidence like we expect to have, or is it presumed to be necessary for the purpose of proving genocidal intent. We saw that tribunals used these kind of additional evidentiary instruments to detect genocidal intent. Basically, the idea of those additional evidentiary instruments is to connect results which we have with some acts, even though there is no strict link between those acts and genocidal intent. Mm-hmm. So what they did, they actually applied two sorts of instruments, let's say roughly two sorts of instruments, or two-flawed test of genocidal intent. It was required that acts committed against the group are discriminatory. So that group needs to be discriminated against other groups while committing that particular act. And the other evidentiary instrument is a scale of committed atrocities. That's how they refer to it. So if the group was vastly devastated by the act, in whole or in its significant part, then we could claim that elements of genocidal intent are present, or equivalents of genocidal intent are there. So I'm not quite familiar with the policies which you have mentioned and with the result that is publicly announced, but still the result is perhaps indicative of some equivalence of ongoing acts that are perhaps similar, at least similar to those of genocide. So what is the actus reus of crime of genocide is preventing birth within the group. And it was at the maybe a few decades ago disputed if genocide can be committed through abortions. There was a long-lasting opinion in theory that abortion is a measure of population control, measure of family planning, etc. So as such, it cannot be qualified as genocidal intent. But lately, due to the developments that occurred in reality, actually, science, legal science, accepted abortion as a potential instrument of genocide. So prevention of birth does not necessarily refers only to creating conditions that are unfavorable toward that group. It is sometimes enough to prove that abortions are performed with, of course, genocidal intent, which is difficulty, as I said. So if we frame discussion in this manner, we can claim that there some equivalents are apparent. We have result, we have scale of committed atrocities, even though it might be early to say atrocities. And we do have this discriminatory element. Do we have discriminatory element is, of course, one of the legal issues which should be debated here. What might be a problem or challenging is to claim that discrimination against non-persons, because children before birth are not treated as a persons within the legal systems of most of the European states. So can we discriminate against something that is not a person? That might be the problem. But if we ask competent bodies within the system of Convention for the Rights of the People with Disability, they would say, and they have written it in their opinions, that such practices are discriminatory against persons with disabilities. So it is perhaps enough to claim, even though it is apparent, discrimination is apparent, that we do have already within the body of international law at least some soft law sources claiming that it's discriminatory. And for instance, they were evaluating a law in Spain which introduced malformation as sole ground for abortion, and they consider it for discriminatory. Also, there were some developments of parliamentary commissions across Europe which were inquiring about discriminatory elements of abortion based on the malformation, and there is no actually objection to consider it for discrimination. And what is actually discrimination that we are talking here? It is possible to abort a child in the later terms of pregnancy if it has malformation. And if we compare it to the able-bodied children, we can see that they are safeguarded from the earlier stages of pregnancy as compared to disabled-bodied children. So the different treatment is apparent here. But I say, again, it was legally disputed if it is discrimination, even though the different treatment is so obvious. And again, competent bodies have qualified it as a discrimination. So if we do have discrimination ongoing, if we have such a scale of acts that resulted with extermination, full extermination of one group, so those are actually evidentiary instruments that were used by tribunals, and it was enough for them to qualify some act as a genocidal, with genocidal intent.
I wanted to ask you, could you elaborate for a moment a little bit more on the concept of non-persons? That's very interesting in my opinion, and I will explain towards why. As you obviously know, in Europe, there are various abortion legislations depending on the country you're in. Abortion is legal up to the 12th week in many countries. It's the case, for example, in Belgium. It's the case in Hungary, for example. I know that in the Netherlands or Great Britain, there are it's 24 weeks, for example. I insist on here that the conditions under which it is legal are quite, I would call them vague, in the way that the margin of interpretation is pretty large, in the way what is a dangerous illness, for example, or there are these formulations which can be interpreted in different ways. And I believe that it is one of the keys to answer many of these questions. Are we talking about an extermination of a population if these are not people, right? And my question to you would be, how could we try to make a sort of consensus, international consensus, is it even possible, on agreeing that, okay, children, for example, in 24th week of pregnancy, they can be, born already, they are early borns, but it's not anymore a miracle from science to keep them alive, which was the case 30 years ago. It was never seen, but nowadays it's almost commonplace, right? Which leads to a situation where a woman, let's say she's at the 23rd week of pregnancy, the life of this, obviously, human being depends solely on her goodwill to have him born or her born or not, right? And so, coming back to my question, is there a way to form a kind of international consensus on the beginning of when this person to be born can be considered as a person, or is it naive, wishful thinking?
Well, many questions are actually open through your debate, and I will try to refer to each of them, and I'm asking you to remind me if I miss something. So, relying on our previous discussion about genocide and discrimination, it should be borne in mind that protected entities for the purpose of Genocide Convention are not individuals. The object of protection are collectivity, groups as such. So it's not, for the purpose of convention, important if the individual member of the group was discriminated and could be eligible for discrimination. It is important to see if the group as such is mistreated in described way. And if we are having narrowing population of the group, so decreasing number of that group due to some legal frameworks, apparently that legal framework discriminates against them. And I explained during the previous question how. And the group itself is victimized, not an individual member of the group. So that should be clear at this point. And what is the concept is to connect the member of the group and his or hers destiny to the group itself. So if you're eliminating members of the group, regardless to their legal status, you're actually exterminating the group itself. And you're actually committing a crime against the group, even though the member might not be treated, sole member, might not be qualified to be treated as a victim. So the next issue, which might be confusing, is issue of personhood. So, do we need to have personhood status in order to be protected against killing? I think that the answer is no. Personhood is a legal construction, and it is important for some civil and other rights. But when we come to the body of human rights, which actually have subject for their protection bodily functions, it is enough to be a biological unit to enjoy certain protection. So you don't need to be qualified for the personhood recognition in order to have your life as a biological fact protected.
As a human being.
Yes. And that is what the European Court of Human Rights underlined in the case Vaux versus France, where it said that embryo enjoys some scope of protection due to its human race membership, if not based on the right to life, but on the basis of its dignity, regardless to its personhood status. So it's clear legal separation between persons and eligibility of one entity to be recognized within the concept, and the protection of the entity itself, at least against killing. So I think it's clear now. And now when we are talking about international consensus, of course, it's over to idealistic approach. I think it's impossible to reach it for different reasons. When we were drafting current international sources of international human rights law, it was an issue about the beginning of right to life protection. And the main arguments for leaving it from the wording were actually those of the political and those of the practical nature, practical or legal nature. In the political sense, they wanted to have instrument that is broadly accepted by different states with different approach to the issue. So that's why they omitted it. But from the legal and practical perspective, it was not decided because back then we didn't knew when life begins in the biological sense. And it was not responsible or reasonable to expect the state to provide protection from the moment which is undecided. So it simply wouldn't be enforceable. In that sense, it shouldn't be confused that right to life has three elements. One of them is right not to be killed, which should be applicable or extended to preborn period. Again, as you mentioned, today some things are possible that were not before. So we know today, based on the relevant science like developmental biology, embryology, etc., when human life begins. It's not disputable anymore in the field of those sciences, but what lawyers are disputing is the moment when we are going to confer some sort of protection to undoubtedly member of the human race. And I wish to say that in that sense, progress of science actually enabled broader protection of the non-persons, human non-persons. You mentioned that it is possible to survive at 24th week of pregnancy for premature babies. And that actually threshold is decreasing, and it's closer and closer to the conception itself. So if we are going to be able, technically we are already able to develop technique called ectogenesis, which would enable full gestation outside of the woman's female body, then we can use that technology for premature babies regardless to the period when they were came to this world, let's say. So we will have actually technological possibility to save, to provide life-sustaining treatment. But the question is, who are we going to do it? Are we obliged to do it, and since when? And in that sense, confusion might arise. And as I see how literature is developing and treating the issue of those technologies, emerging technologies, is a confusion about the purpose of abortion itself. And there should be no confusion. If you take a look at the European legislation, neither of them says or prescribes that legal purpose of abortion is to kill the unborn child. So legal approach to abortion is that it is a medical act designed to interrupt pregnancy, basically to disconnect woman from continuing pregnancy and providing her body as a host for developing child. If we understand abortion in those terms, we will have no legal dilemmas in the future when those technologies are actually become available in the public health care system. But we can also detect developments in the theory, at least according to some authors, that the purpose of abortion is actually to kill unborn child, which is entirely wrong and not accepted from even from the, let's say, feminist scholars who are in favor of my body, my choice. But for instance, Peter Singer and others do not extend right to choose how to use your body. They are not extending it to the extent that it encompasses right to decide to kill someone, especially if that someone is viable or able to survive on its own. This should be understood in broader sense. Able to survive on its own doesn't mean to leave it in with no treatment and if it is sustainable or not. But able to survive on its own means regardless to bodily functions of the woman, regardless to the bodily functions of the host. So if we are able technically, medically, to provide life-sustaining treatment, that eligibility to be qualified as self-sustained and viable is actually lowering the level and threshold needed for life protection. If we take that analyze of the diverse European legislations, they are actually limiting abortion with the stage of viability. They are considered that after that stage, it shouldn't be permitted to perform abortion, regardless on the grounds for it. And with technological development, that viability is actually decreasing, and it is expected that the level of protection of life, we don't necessarily have to say to protection of right to life, because protection of right to life is protection of legal category right. But protection of life is broader. It can be protected on different ways. Right to life is just one tool to protect life as a biological fact. The other powerful tool is, of course, dignity. So the level of protection of life, human life, will increase with technological progress. That's what I firmly believe.
Professor Dragan Dakic, thank you very much.
You're welcome. Thank you.